Good afternoon, everybody, and welcome any members of the public that will be participating in our meeting. The meeting of the Board of Chiropractic Examiners Enforcement Committee is being held by teleconference pursuant to statutory provisions of Government Code Section 11133. The date is Friday, December 9th, 2022, and the time is 12:30. The board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes unless in the discretion of the committee, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items except to decide whether to place the matter on the agenda for a future meeting. Please be aware that the meeting is being recorded. Please turn off or silence all cell phones. We will now take the roll. Dr. Paris, will you call the roll?
Yes, Dr. Lawrence Adams,
Present.
Mr. Raphael Sweet,
Present.
and Dr. David Paris, present. You have a quorum.
Thank you. We will move to agenda item number 2, which is review and possible approval of October 6th, 2022 committee meeting minutes. We'll open this item up for discussion at this time. If there are any questions or comments among the committee members. Hearing none, is there a motion?
I'll move to approve the October 6th, 2022 meeting minutes.
Second.
Excellent. We'll now open it for public comment.
And this is the moderator. We're opening up the WebEx Q&A feature to facilitate public comment. If anyone has a comment on the minutes, you may look for the question mark icon, typically in the lower right of your computer screen. Click on the question mark, type comment in the text box, and click send. The other option is to raise your hand by clicking on the hand icon. And does anyone have any comments on the minutes? And I see no request for comment at this time. Shall I close public comment?
Yes, thank you.
You're welcome.
So we'll now move to agenda item 3. Oh, sorry, call the roll, Dr. Paris. Or excuse me, call for the vote.
Thank you, Dr. Adams,
Yes.
Mr. Sweet,
Yes.
and Dr. Paris, yes.
Thank
Motion
you.
pass.
Agenda item 3. So update on the board's enforcement program. Ms. Walker, I'll turn the time to you.
Sure, thank you. So my update today will be rather brief. We did just meet 2 months ago on enforcement. One item worth noting is that, as you recall, at the October 27th, 2022 board meeting, the board did adopt its 2022 through 2026 strategic plan. Following that adoption, staff participated in action planning sessions with DCA's Solid Training and Planning Solutions on November 29th and 30th, and then on December 5th. So the plan moving forward is based on that action planning session. Solid is going to draft an action plan based on those discussions, and that's going to outline the various tasks that staff needs to complete with identified timeframes for us to be able to implement each of the objectives that the board identified within that plan. So Solid is planning to get us that draft this month, and we plan to present the final action plan to the board for discussion during the January meeting. The other item that enforcement is working on currently is expert recruitment. Unfortunately, we've fallen a bit behind from my last update in terms of making progress on that item, but we are planning to release the recruitment by the end of the year so that we can have a period of about 30 to 45 days to accept applications for new chiropractic experts. And then after that portion's complete, we would do the internal evaluation of the applications, and any of them that meet the vetting requirements to be eligible for the application process would be presented to members of the enforcement committee for interviews next spring. Let's see here. Another item to highlight is there's various proposed regulations that affect the enforcement program, and we've been really working very closely with our regulatory council to identify strategies so that we can move those different regulations forward. When it comes to within the disciplinary guidelines and the uniform standards, as you recall at the last board meeting or at the last enforcement committee meeting, the committee discussed some potential terms and conditions of probation and provided feedback. So the remaining step on that item is for us to draft the different parameters for minimum and maximum requirements for violations of the specific statutes and regulations within the board's jurisdiction. So we're working on the development of that with plans to potentially present that to the enforcement committee at the spring meeting. We also have the proposals that are related to the Consumer Protection Enforcement Initiative, branded as CPEI. The enforcement committee and the board, excuse me, separated those into 6 different proposals. And as we've evaluated some of the different components within those regulatory proposals, some of those matters fall within the realm of licensing. So we're going to effectively move them forward. The plan is to move some of the items relating to filing of addresses and notice posting requirements at the place of practice and things to that effect to the licensing committee, while we proceed forward with the other items that are strictly enforcement matters. So we have some of those. One of the proposals for Section 312 will be discussed as an agenda item later today. And another agenda item is also part of CPEI on the sexual misconduct regulation. So we'll be discussing 2 of them, and then we're going to be developing the remaining 2 for future discussion at another meeting. And another item that we're working through the enforcement committee on is the record keeping requirements for chiropractic patient records. The enforcement committee at the October meeting gave us feedback and direction on developing those requirements, and we've identified Dr. Paris as our technical expert to assist us. So as we get into the end of the year and early next year, we'll be putting that proposal together with plans to bring it to the enforcement committee at that spring 2023 meeting. See here. That's, as far as my update, that's really all I plan to highlight. There are some statistics within the meeting materials. They are in line with kind of what we've been seeing. Our pending complaints number is hovering around just a little over 400, and we're planning to get that down by the end of the fiscal year. The number of pending cases that we have at the Attorney General's office is declining, which is as expected when we hit our peak of 107 last fiscal year. But there's not too much else there to report. There's no unexpected trends. And I'd be happy to answer any questions from the committee about any of the items relating to the enforcement program.
On the complaints received for fiscal year 22-23, we're at 187, which is a lot lower than the previous years. Is that just because we're not done with that cycle yet? Is that why it's lower?
That's one reason. I think that's, if we continue to see that trend, especially after we get through December and into early next year, I think we'll dive into it a little further and try to kind of identify if there's a particular reason. We did open up the online complaint form, and then we still receive some paper applications, but we could look into that a little further to get some answers on why there's a decrease compared to the last fiscal year.
Thank you.
Okay, I have no questions. Any other questions from the committee?
No questions.
Okay, thank you for the update, Ms. Walker. I think since that was an update, we don't necessarily need to take public comment on that, or do we?
You can, this is Sabina. Good morning.
Good morning.
You can absolutely take public comment on an update.
Okay. Do you recommend we do that then?
It is up to you. It's the best practice. And so I
Okay.
think it would be a good thing to do.
We'll do that then. Okay, moderator, if we could open that up for public comment, that would be great.
Absolutely. So we've opened up the Q&A portion of WebEx to facilitate public comment. If you have a comment on this agenda item, you can look for the question mark icon in the lower right corner of your WebEx screen, type comment into the text box there and click send. The other option for anyone is to raise your hand to ask to be recognized. And to do that, you can click on the hand icon, or if you are a call-in user, you can press *3 to raise your hand. And I see no requests for comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Okay, we'll move to agenda item 4. Review, discussion, and possible recommendations regarding proposed regulations for disciplinary decisions involving sexual contact with a patient and required actions against registered sex offenders relating to Title 16, Sections 384.1 and 384.2. I think I'll turn this over to Ms. Walker to take the lead.
Sure, thank you. So this agenda item is a continuation of the discussion from the October committee meeting as it relates to the proposed regulations under CPEI to add Section 384.1 relating to sexual contact with a patient, as well as Section 384.2 relating to registered sex offenders. So within the meeting packet, agenda item or attachment number 1 is the proposed text that was previously approved by the board in 2016 under CPEI. And within that text, what that regulation would do would be require that any proposed decision issued by an administrative law judge that contains a finding of fact that a licensee engaged in any act of sexual contact as defined to contain an order of revocation. And that proposed decision shall not contain any stay of the revocation. Whereas if the decision was issued by the board, there could be a stay, but there must be a revocation. So if this were to be implemented, the board couldn't do anything less than revoke the license and place the licensee on probation, and an administrative law judge couldn't issue a decision for anything less than outright revocation. There's also the text there to add Section 384.2, which would be required actions against sex offenders, and it would require the board to deny an application for licensure or revoke a license of any individual who's required to register as a sex offender pursuant to Penal Code Section 290 or an equivalent law in another jurisdiction. And that regulation would even prohibit the board from reinstating or reissuing a license to said person, or issuing any type of stay of a revocation for a licensee and placing that licensee on probation. At the prior meeting, there were some questions about the registration requirements for sex offenses in California, and there have been updates that were made through Senate Bill 384, made beginning January 1st of 2021. It transitioned California from the lifetime registration system that had been in effect for many years to a 3-tier system with differing levels of registration requirements and associated timeframes just based on the type of offense. So the minimum level is 10 years, then there's a secondary level of 20 years, and then the 3rd tier is a lifetime registration requirement. What that bill also did was beginning July 1st of 2021, provided an avenue for those who are currently on a list to be able to petition the court for removal after they've served their mandatory minimum time on the registration list. We did evaluate some of the different regulations that are in effect by the other boards relating to this topic, and we generally found that the other boards have registration or they have requirements within their regulations that similarly would do what this is intended to do, to prohibit anyone who's on the sex offender registration list from being eligible for licensure as a doctor of chiropractic, or in their case, the other healing arts professions. One item that staff would like to note for the committee as they continue the discussion is by moving to the tiered registration system, it does allow, I think it's a good response to some of the committee's concerns about the need for ensuring that there could be extenuating circumstances. But by moving to that tiered registration system and the ability to petition the court for removal from the list does allow for anyone to petition and get that relief through the court, which then could be applied through the disciplinary process. So as far as for today, what staff is really requesting is that the committee continue its discussion about these regulations. And if there needs to be any changes there beyond any type of grammatical type edits, that we can update to it. But if there's any substantive changes or discussions that may need to be in place before this could move forward back to the board. So with that, I'd like to turn it back over to the committee.
Okay, we'll open it for discussion for the members of the committee. Dr. Parrish or Mr. Sweet?
I just have a clarification, maybe discussion. So is my understanding then that with the 3-tier system, the minimum amount of time that somebody would be on the be registered would be 10 years?
Correct, for an adult offense. For a juvenile offense, it would be 5 years.
Okay. And so the language that we have would not allow us discretion as a board for anything less than a 10-year wait period.
Correct, unless they were able to successfully petition the court for removal of that requirement or relief from that requirement.
Okay. Okay.
Do we have an explanation of what a tier 1 level of offense is? Perhaps Mr. Sweet, you probably are a little bit more, do we know what do we have that language of what a tier 1 is? If that's the least, right? You're saying tier 1 is the least, that's the least level or the least punitive? Is that what I'm hearing? And that a minimum is 10 years on the sexual registry?
Correct. So the tier 1 is the minimum level, and that's generally applied to offenses that are misdemeanor in nature, that are sex offenses, and it has a 10-year period. Then there's a tier 2, which as you go from tier 1 to tier 3, the level of offenses increase in severity. So if it's a more severe sex offense, it would be 20 years, or if there's a repeat offense, they would apply the 20 years. And then for the lifetime is for the most severe sex offenses, including things like rape. So it progressively increases as you go through the tiers. Okay.
But I'm not interested in getting graphic here, but I'm just saying, do we have like an example of what a tier 1 would be? It's a misdemeanor. Is that like, drunk or like indecent exposure, something like that?
Correct. It would be like misdemeanor indecent exposure, but that's also within the language before the board. That's one of the, in subdivision B, that the section shall not apply to the following. That's where there would be some discretion, is in subdivision B2 for an individual who's required to register as a sex offender pursuant to section 290 solely because of a misdemeanor conviction under section 314 for indecent exposure. So what it applies to is really the sex offenses that do require registration. And as they go through the penalty phase during a criminal trial, there is the prosecutorial discretion on how they plead cases, and then ultimately what sentences are imposed. So in these cases, what this regulation would do is exclude anyone from the profession that's required to register as a sex offender, with the exception of someone that has a misdemeanor indecent exposure conviction.
Okay, that's what I was wondering. So if they have a tier 1 that fits, that we learn a little bit more about, that wasn't necessarily where they had physical contact with another person, or based on our judgment after we hear the facts, we have a little discretion on that one area. Is that correct?
Correct.
So would technically still have to be, they would still have to be registered and probably have to disclose that, but that we could also allow them to get a license, say if they were a student pursuing a chiropractic license, or are they excluded for 10 years under those circumstances?
That's correct. This regulation wouldn't apply to that circumstance. If it's a misdemeanor indecent exposure conviction, then regardless of whether they're required to be on the list, this particular regulation would not apply to them. So they could be granted a license, or if they already are a licensee, they could continue practicing, likely under supervised probation by the board, but we would be required to outright revoke their license.
Okay.
So
That seems reasonable. That seems reasonable to me. I think that was the spirit of what we were discussing. So, I mean, other than that, I personally like the language. I think that's reasonable.
just to be clear, this only allows discretion for misdemeanor indecent exposure, period. Not all these other instances or situations. Those we would not have discretion, because this would only apply to 314.
That's correct. As it's drafted there, it only would be misdemeanors under section 314 of the penal code. So indecent exposure. We would, when you look at the different other types of penalties that would potentially fall within that, if you would only be really expanding to sexual battery, but then that would require a revocation, likely under section 384.1, where you're talking about sexual contact with a patient. It's going to start falling under those circumstances as well.
I seem to recall we had more examples of potentially less egregious convictions. Maybe I'm mistaken, but I other than just, the example of like indecent exposure.
I should point out, and I forgot to mention that earlier, as part of the tier registration requirements, they've carved out exemptions for circumstances where if someone had a consenting relationship with an underage adult, if they're within 10 years of that person's age, like if something occurred when, someone was 19 and the victim was 17, there's exemptions within that requirement for them to be registered. So it would rely on the court's discretion. If the court didn't impose the requirement that they register, then they would be okay under this regulation. Or the committee could consider using language that's comparable to what those carved out exemptions are from the registration requirement. And you could place that in the regulation. And then even if the court didn't require registration, the board could potentially have discretion there. So that's kind of the only other portion I think that could be opened up a little bit further.
Thank you.
Well, my recollection of our discussion was that very thing, is that giving us some ability that if a person is at a certain level of offense, because I mean, I'm sure that I don't have the code in front of me, but I'm sure there's, and maybe Mr. Sweet, you can, touch on that there's probably a myriad of things that would be like on that tier, on that same level, that I kind of got the impression that was what the board wanted, was to have a little bit more ability to, if somebody does apply and is, say, a tier 1, and we find out the facts of their conviction, that we would have some discretion rather than just narrowing it to one area. That we would, I mean, I get if it goes to tier 2 or tier 3, that's a whole separate level. I think that was kind of the spirit of the discussion that we had, was that we weren't locking ourselves in or just kind of saying everybody that has to register is out of luck.
That's an opportunity there where I would say that you could take a similar approach as with what's under 384.1, where within that regulation, it requires that an administrative law judge make a very specific finding and issue a decision for revocation with no stay, but then still gives discretion to the board to ultimately be able to put the person on probation. We could explore options to that effect where rather than having a regulation that not only specifies what an ALJ would be required to put in a decision, but then also forces the board's hand, you could look at broadening it where the board does retain that discretion, and we could work with regulatory counsel to draft something to that effect, particularly if you wanted to keep it to tier 1. And if someone's under tier 2 or tier 3, it's an automatic revocation.
Well, aren't tier 2s more in the felony? Obviously, much more significant.
Correct. Yeah. So tier 2 and tier 3 are pretty significant for you to offenses. So I would probably advise against having discretion there and just making it outright. The benefit to the regulation is that by outright saying this is what the penalty will be, if we get that passed, then when those types of circumstances go forward, we're not having to go through a very drawn out adjudicative process to prove the facts. It would just be there's a regulation that says, you know, if this conviction's occurred, this is the penalty outcome, and it would benefit us on the appeal process if someone was appealing a decision where we didn't have this regulation. But that's where there are options there, and we can provide a little bit more discretion for the board in the text that we bring to the board.
So what if somebody does have, say, a tier 2 or tier 3 conviction, using that example, and they're able to get their name off the registration list and have their conviction expunged or whatever, and so they technically no longer have that on their record? Where do we stand with that?
So under that, this regulation wouldn't apply to them because when they've been relieved of that registration requirement, then if they were a current licensee and they were revoked and then they were able to get themselves off the list and get their conviction expunged, they would go through the reinstatement process and they would file a petition before the board. They would appear before the board, outline those facts, and the board could grant the license back. If it's an applicant, we would get the information as part of the background check, and then we would know that the conviction's been expunged. We likely wouldn't have any grounds for denying the license, or if we did, we could put them on probation. But that's with what this regulation does, is it outlines what the criteria is if you're on the list. So the first step is for the offender is to get relief from the court to be off the list, and then this no longer would apply to them.
Thank you. Appreciate your clarifications there. Any other discussion?
I have another question. Is tier 1 all misdemeanor violations?
Yes. I'm trying to navigate to the list they have there. It's reserved for the ones that are not. Get tier right in front of me here. So they define a tier 1 offender as being subject to registration for a minimum of 10 years. And that's for a misdemeanor conviction described within the subdivision. And then it's also for a non-serious felony. So it's mostly misdemeanors, or if it's a non-serious felony as defined in the statute. So you potentially have felony offenses as well with a 10-year registration requirement.
Yeah. Okay. Thank you.
Appreciate that this gives us a little bit of flexibility with the tier 1. I don't anticipate that we would really need much discretion for tier 2, tier 3 anyway. So I think I like where we are.
I concur.
Yeah, same. I think the discretion goes, it's kind of back to the conversation that we had previously about having a little bit more discretion than, I think for this discussion, just a little bit more than the the specific, 314, but maybe something that's more around misdemeanor and tier 1 in general.
Excellent. Does that give you enough direction, Ms. Walker, for you and staff going forward?
It does, and just to clarify, the discretion is solely for the board, correct? We do not want any discretion for administrative law judges there to issue a decision with revocation under any of the tiers, and then retain authority for the board to have discretion under tier 1.
That's my understanding.
Yeah,
That would be my
I
preference.
like that. Yeah, I'm with you. I like that language. It gives us the discretion, correct? Because if we leave it to them, then we're stuck with what they decide.
Correct.
Yeah, I'm with Dr. Parrish and Mr. Sweet. I like what you've put forward. So do we just need do we need a motion here to instruct you to continue on that, or is this more of a discussion and you guys just continue to work more on the language as we've done in the past?
We've taken, we know which changes need to be made. I think procedurally, it's kind of to the discretion of the committee. If you're comfortable with that framework moving forward to the board, you could direct us to make those changes and present it directly to the board for the next discussion. If you want it to come back again at the committee level, we could do that as well.
From speaking for myself, I'm comfortable with the language as it is. I think we're all on the same page. And I think the more that we can move these things forward and give you the power to move them forward, the better. So if you need a motion that says, go with what we got, I'm comfortable with that. Any other comments from the committee?
Well, I think staff was going to work on some of the discretionary language in 384.2. Is that correct?
Correct. The intent there is that we've got the language that's in effect. We'll work with regulatory counsel to reflect the committee's discussion today of providing the discretion on tier 1. And then the decision is whether you want that to come back at the committee level to continue the discussion, or if you're comfortable with us working with regulatory counsel to reflect the committee's intent and then just bringing it directly to the board for further discussion.
Yeah. So I think the expediency, correct me if I'm wrong, the expediency would come by moving the staff language back and just moving it back to the full board for a vote versus bringing it back to committee and then bringing it back to the board afterward.
Correct. That would be our preference, is to move it directly to the board.
Yeah. So what kind of a motion do you need to give you the authority to do that?
We would need a motion, or Sabina's about to jump in, so I will let the attorney give us the motion.
Right.
I'm sure your motion's just perfect. I don't know. I'm not the be all and end all of all motions, but I'll give it a go. You can recommend to the language as presented today with the suggested edits for sections 384.1 and 384.2 to be moved to the full board for consideration.
So moved.
Perfect.
Second.
Thank you, Ms. Knight. We appreciate your verbiage.
Anytime.
So let's now open this up. Is there any other discussion from the committee? Hearing none, if we can open it for public comment, moderator, thank you.
You're welcome. We've opened up the WebEx Q&A for facilitation of public comment. If you have a comment on this item, you can look for the question mark icon, typically in the lower right corner of your WebEx screen. Type the word comment into the text box and click send, or you may raise your hand to be recognized to comment. If you are a call-in user, you can press *3 to raise your hand. Are there any comments at this time? And I see no comments. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
All right, Dr. Paris, if you will call the vote.
Yes. Dr. Adams,
Yes.
Mr. Sweet,
Yes.
and Dr. Paris is a yes. Motion passes.
Thank you. Good discussion. Okay, agenda item number 5. Review, discussion, and possible recommendations regarding the authorized activities performed by an unlicensed individual within a chiropractic practice. Discussing amending CCR Title 16, Section 312. I will turn this over to Ms. Walker for further insight. Thank you.
Sure, thank you. So this is the second proposal today that was originally part of CPEI that we're bringing back to the committee for if there's any further discussion that needs that would be necessary, or if the language can move forward as is. As far as background, what Section 312 does is it outlines and clarifies the role of unlicensed individuals within a chiropractic practice, and it establishes the supervision requirements for the doctor of chiropractic who's going to be overseeing their activities. And with the language that's in the committee materials, that's what was approved in 2016. We're bringing it back mainly for 2 reasons. One, particularly for feedback from the professional members, if it adequately and addresses all of the role of an unlicensed individual within a chiropractic practice. And then the second reason being that we received a public comment at the last board meeting specifically about 312 and the fact that it makes no differentiation when we reference an unlicensed individual. It doesn't include, or that definition includes someone who by this board, their license was revoked or surrendered for any type of misconduct, including sexual misconduct. And there's nothing within this regulation that would prohibit them from working as an unlicensed individual within that practice. There's, from the staff perspective as well, we're defining the term unlicensed individual, but we may want to consider using a more appropriate term to describe the support staff within an office. And it may be necessary that we differentiate between that staff that's truly unlicensed, that they're not regulated by any entity, and maybe staff that's working within an office in a multidisciplinary setting where they're working under a license issued by another healing arts board. So at this point, we really want to return this back to the committee for a discussion of the language and any feedback on some improvements or changes that we could make to that language.
Thank you for that introduction. So a couple of things as I reviewed this that came up, and I had a discussion with one of the former chairs of the board, Sergio Azzolino, and I spoke, and he made some good points. And one of the things was the section under physiotherapy, which tends to be kind of the bigger issue here, along with the exam, although I think the language relating to taking the history and exam is pretty consistent with what was there before, and just makes kind of minor changes there. But the one section under physiotherapy, they changed it to indirect supervision. And so I think a good suggestion is that we might look at language that says direct order of the doctor. And then the comment came up about the fact that we have a section that says the individual, the licensed doctor shall be present in the same chiropractic facility with the unlicensed individual at least 50% of any work week. And the comment came up was if they're under direct order, the doctor's met with them and they have given a direct order, and say the doctor goes out of town on a Tuesday, so they're not going to be there, they'll be there less than 50% of that week, they technically could not follow through with what the doctor had ordered the remainder of that week, because the doctor would not meet the 50% section. So the direction, the suggestion is that, perhaps either decreasing that time or eliminating the time and just having it so ordered that there is a direct order, that the treatment is under direct order of the doctor rather than using the term supervision. And then perhaps dropping the time, because if they can do it when the doctor's not there, at those times, then the 50% thing is a little bit limiting, if you will. And so I see the merit to that. If the doctor has evaluated and has directed the order and the physiotherapy to be performed, so it's under direct order of the doctor, as long as the doctor is accessible at some point, if needed under an emergency question or something like that. I think that those suggestions had merit.
I'm wondering how did we operationally define work week? Is there an assumption
not
there as to
aware.
what that means? Yeah.
Well, this language has been there for a long time, and actually, this, as Kristen pointed out, this goes back to discussion in 2016. So I know that the 50% is in the language right now, but I don't know about the discussion of a work week. That's a great point.
Yeah, I think we might want to consider defining, what the work week actually, what we mean by that. Is it patient care time? Some offices are open 40, let's just say 40 hours a week, but their actual patient care times are less. And so are we, what are we actually talking about there? And maybe a longer discussion, but that's the one vague part. And then I think the other thing that I was wondering about was that we note physiotherapy as a term of art there, but I'm wondering, does that include things like rehabilitation exercise?
Excellent point.
And if it does, maybe we either discuss that or consider, adding specifically adding some other language to that.
I was going to ask about that myself, is what is included in physiotherapy versus the previous language of physical therapy anyway. There's a non-chiropractor on the board, I'm not sure.
I think the change from physical to physio is more in line with the Chiropractic Act because of the fact that physical therapy has its own entity. I think that's probably the reason staff changed that to physiotherapy, because that's consistent with the Chiropractic Act. My feeling is that I think we should just drop the requirement for time, because the work week is so unique to each practice. I mean, I know chiropractors that work Monday, Tuesday, Thursday, and that's all they're there, and they adjust for 3 hours in the morning, 3 hours in the afternoon. So they're basically working 18 hours a week. So but they have other things going on in their practices on the days that they're not there with staff. So I kind of like that idea that it, if we say that it's under direct order of the doctor, and then we can define direct order, meaning that the doctor has met with, evaluated, and is directly ordering or directing the care that is being administered by the unlicensed individual in the practice. And that as long as there's a standing order of what to do, then that order can be carried out without the doctor having to be a requirement to be there 50% of a work week.
My concern is that we struck the language in 3 requiring a periodic reevaluation. And I know that kind of mirrors what the physical therapist, some of the regulatory language that they have in relationship to either aides or assistants. I'm not sure. I sometimes get confused with which regulation goes with which for them, but I know they have some regulation that requires the actual licensed physical therapist to do a reevaluation, or at least meet with the patient every 30 days and reassess the treatment plan and their progress, etc. And that may be separate there. But my concern about not requiring something, I mean, I'm not sure that the licensed doctor of chiropractic with that necessarily just being in the office 50% of the time gives us assurances that that patient was there during those periods. And, maybe um, I think something more like what was in 3, where we have assurances that that licensee is actually reassessing the patient. And the other thing is too, what if they put them on a treatment plan, like say a chronic pain management type of episode of care or treatment plan, and they're seeing them once a month, potentially for 6 months, and now we can have a patient coming in for some sort of physiotherapy or rehabilitative care, however we end up defining it, but then they have not seen the chiropractor, the actual licensee, for 6 months. I mean, I think there's some room for I think we need to strengthen that.
Well, I concur with you. I mean, I think if that would be a good trade-off, is to drop the time commitment, but that makes sure that the doctor is having that periodic reevaluation. I think that's I mean, I think that's very consistent with good best practice of care, is that, whether a person's coming once a month for kind of chronic patterning, you should still be assessing them each time they come in. Whether
Yeah.
it's a brief or cursory evaluation, there should be something, I notate, updating, when they come in that infrequent time. So I think that's a reasonable thing to add back in to strengthen that. I think dropping the time requirement, because I see the point of when somebody's gone, you don't want necessarily your practice to come to a halt if there's things that staff can do while you're gone. But I see that that there needs to be the practitioner touching base, and periodic reevaluation, I think, is appropriate.
And I also think that we may need some language around defining readily available. That seems a little bit vague and without a time frame or immediacy. So maybe it's as simple as defining immediately available, and I don't know if that's by verbal, some sort of direct verbal contact, I would think. Versus like texting or all the other ways that we can contact people these days. And I also think there should be maybe some language, and I don't think I missed it, but maybe some language that identifies a patient presenting with a new chief complaint or any change of condition. Like those would be reasons that I'd like to see us, require that that contact is made between an unlicensed individual. I think I don't want to conflate, the unlicensed for DCs with it's not there's not direct equality to what goes on with physical therapists, where they actually have PTAs that are trained, and there's kind of some scope definition around the assistants. There is, and then also like the aides and how it's defined, what their job duties are, and there's some, I'm not sure, but I believe there's some kind of defined training there. We don't know what type of training when we say unlicensed in a chiropractic office. I could have my mom doing it tomorrow. And I'm not sure that gives us assurances of safety. So I think our guardrails are like the contact and the things that we were just speaking about.
So are you comfortable with dropping the 50%, or that type of thing, if we add in the periodic reevaluations and then define more what readily available? I mean, I'm open to anything like that. I think that my idea of readily available means that you can get in touch with the doctor, and if you can, to clarify something, then great. If not, then you hold steady. Here's an example that I think of when I think of this is that if I make a recommendation for, say, cold laser, and I have a staff administering cold laser, sometimes the patient will come in and say, well, my direct order is for, say, their knee or their hip. And the patient will be like, hey, can you sneak a little bit in on my shoulder? Our staff has been instructed that no, I cannot do that. You need to discuss that with the doctor, and we need to have that ordered. I cannot go outside this order. So that's kind of where I think, where our staff has been instructed. You don't just sneak that in. You can bounce out and ask me, and I can go in and touch base with the patient and say, well, what's going on with your shoulder, and talk about it and say, well, let's just get this done today, and then have them bring you in a room and we'll evaluate that and have a little more discussion about it. They don't just go ahead and do it. So that's kind of the idea, in my opinion. What direct order means is that they don't deviate from what you've put on the outlining of the care.
Yeah, agreed. There should be no, really, with an unlicensed individual, there should be no changes to necessarily to the therapeutic parameters, barring, you're doing ultrasound and you've defined the time and the intensity, et cetera. The patient has a complaint. Of course, we want that person to stop, right? We don't want them to think that, oh no, I have to do this to you. But at the same time, an unlicensed individual with necessarily, we can assume no understanding of the mechanism and the heat generation, and just using ultrasound as an example, there's potential for harm.
Right.
And we could probably name a lot of other therapeutic interventions. So I think, yeah, I'm not sure. I'm still kind of thinking about the 50% of the work week. I think we do. I think it's in the interest of public protection to have some assurances that the licensee is actually spending time on site with the unlicensed staff. I could see the um, the potential for maybe some sort of a little bit of abuse and some risk by not mandating something there.
Well, doesn't the periodic reevaluation kind of help strengthen that?
I think it does. Yeah, I think it does.
Sufficient enough for you? Or are you more comfortable dropping it to 25% and periodic reevaluations?
Well, I think if we define work week, that may lower what we might consider to be, a significant amount of time. I don't know. I'm kind of grinding my gears trying to think about it very quickly here, but um, I'm just not sure at this very moment.
I think Raphael, sorry, I think you had a comment.
Yeah, sorry, I didn't mean to interrupt. As far as periodic evaluation, is that going to be defined as some sort of interval, or could that be like every 6 months, something like that? Or I don't know if we would be comfortable with someone saying, yeah, we do, they check in with me annually, something like that.
Well, I think it's in there. It's 30 days. It would be 30 days. And we could change it. We could say 30 to 45 days, but kind of the industry standard is reevaluations about every 30 to 45 days, closer to the 30-day mark.
I'd be comfortable with that.
How about the time? What do you think about the time of the work week issue?
I don't think, to your point about, different folks have different working styles. Some are in there 18 hours. I don't think we need the percentage, personally.
Well, while you're ruminating on that, Dr. Paris, a little bit more, there's another issue that came up, and that was the fact that we're seeing more practices are becoming interdisciplinary or multidisciplinary practices. And so this particular language refers to unlicensed chiropractors in a chiropractic office. And then perhaps the issue, the issue came up particularly with Dr. Azzolino as he was talking about the fact that he has a nurse on staff, a medical doctor on staff, and a naturopath on staff. So those have their own boards and respective licenses. And so if they are performing an exam, does the same requirement of, the doctor and those, so those were good points to bring up. And I think I had a little just conversation with Miss Walker yesterday about that aspect. And she brought up a great point that, well, they have their board that they are already beholden to. So they're going to be required under this, to their board on what they, for violation or for, practicing what's outside the scope of their license. So, and I know, Dr. Parrish, you've practiced kind of in a multidisciplinary situation at the VA, so you might have some, insight on that as to, where that goes, because you probably have had somebody evaluate somebody and then refer them over to you, and obviously you have to do your evaluation and come up with your own diagnosis, but they may have already diagnosed and you may concur with their diagnosis after your own personal evaluation, I would assume.
Yeah, I would say that's exactly it. Just to answer directly, I would never just assume all of their, findings, even if it's another DC. In other words, I would always do either a new or re-eval and confirm that I would concur with the treatment plan, the positive orthoneuro testing or negative orthoneuro testing, make my own clinical decision on imaging, do my own informed consent, etc. So yeah, I think that's an important aspect of anytime a patient sees a new provider. I don't think you can just make assumptions.
So would it be safe to say that, our regulations our regulations are for the chiropractor and those that are unlicensed, because a nurse is technically an unlicensed person in the office from a chiropractic perspective, but they are licensed by their board, and that allows them to do certain things. So we wouldn't necessarily exclude a nurse from performing an evaluation, even if she were employed in a chiropractic office, that would allow her to do what she has specifically to do under her own license. Or his license. I shouldn't assume it's a her, but their license.
Just to be clear, you mean in lieu of the chiropractor doing it themselves? In other words, like, let's say that the nurse did it, did the E&M portion, and then the chiropractor would walk in and kind of just take over the treatment recommendation and provide care.
No, I was
Okay.
thinking more. The example more of was like, let's say the doctor is seeing patients, in another room. A new patient comes in, the nurse or the MD performs an exam, and makes a recommendation. We need to get X-rays of this area, or we need to do some therapy in this area. Do they have to go then talk with the DC, because that would be in a sense under their license? They have the ability to make that recommendation on their own license.
I think that's other than if it's in a it seems to me in that example that provider, to say whatever, like, healing arts licensee, would be then practicing under their license.
Correct.
And those recommendations would have come under the auspices of their, licensure, scope of practice, regulatory, regulations, etc. I think if a DC were to enter the room from unlicensed or even another licensed, I think there's an obligation to, concur with their findings by verifying them.
Yes.
So there has to be some sort of, verification and concurrence that way. I just don't think you can, completely take over an an unlicensed providers. I don't know. Yeah, I don't know. I think it's getting weedy and tricky. Yeah, but um,
I mean, I think best practice that whoever comes in there is going to verify whatever exam may have gone before and do their own exam and then and pick up the ball from there.
yeah,
I don't think the intent is for anybody to say, I'm going to take your word for it and just pick up where you left off and assume that everything there is as it is.
yeah,
It was just some of those things that were brought up that bring this into because technically they are considered a non-licensed. They're not licensed in chiropractic, but they are licensed in their field. So just thought I'd bring those points up, and that's pretty
yeah.
much what I had. I I personally am comfortable with changing the language to under the direct order of the doctor, and dropping the time commitment, because there is so many, like, I work a 55-hour week. I'm here 6 days a week at the office, but I know there's people out there that aren't doing that. So my work week is very different than somebody else's. And so when we use kind of concrete terms like 50%, it becomes quite prescriptive in that regard. Um, and I'm very comfortable with the language of periodic reevaluations, that number 3 that was taken out, putting that back in, because I think that is the spirit of what. So that would be my feeling. I would be okay with that.
I concur with that.
So no requirement to be present at the same chiropractic facility with the unlicensed individual. Could you do a telehealth visit? Let me just give an example, and I'm of course playing devil's advocate here. Could you do a telehealth visit or have one central location with satellites where you've done the evaluation for the patient, made a treatment recommendation, everything else, and then send them to your satellite clinic where you actually never work, and you have unlicensed staff there providing physiotherapy and rehabilitation? I mean, how long could you do that?
Well,
And then so
they would have to be under direct order. According to what I'm thinking, they would. I mean, that's so foreign to me because I don't practice that way, but I understand we have to think in terms of somebody that may practice that way. I would think in the spirit of it is that there would have to be um, a reevaluation within 30 days. At the longest that a person could go without.
so I'll do it via telehealth and never
Yeah,
actually.
I have a problem with telehealth anyway from a standpoint of chiropractic, because I think that if you're I just don't think you can properly examine a body part, and physiotherapy is assuming that you're doing it to a body part that has been evaluated for range of motion and for orthopedic neurologic testing. And I get it. I guess we have to look at everybody's possible interpretation of it. But I would think that telehealth exams in chiropractic. I mean, it just I get it for some things, but I think I don't get it for a lot of things. But maybe someone can give me an example of telehealth. But
I don't want to derail it. I don't want to derail it with telehealth as the example, because I think there's a lot there too. I would agree, but let's just say it's a hub and spoke kind of brick and mortar model with, multiple satellite clinics around,
Yeah.
one clinic where the doctor never even gets out to, the other. And we just saw, I believe we had some data from another meeting recently showing kind of an increase in satellite clinics and stuff like that. And so let's say you have, 5 satellite clinics and 1 main clinic, and it's all unlicensed staff working in all the clinics. You only work at the hub. Um, I don't know. I'm having a hard time just wearing a like public safety hat and thinking that the licensed chiropractor can almost never be present in the facility where the unlicensed individual works.
And so
And
in
we're
these
not a
examples,
profession that has like aides, like defined things, with
yeah,
with like scope, like an assistant and aides and
yeah. So, I mean, I've never heard of that. I've never heard of an example quite like that. And that brings up a great point. So, um, I mean, by definition of what we have right now, by definition of what we have right now, where they're 50% of the facility, how does that even happen? Those types of facilities would be not consistent with the current regs we have, from what you're saying. A hub and spoke type of practice right now where those satellites are unlicensed, that wouldn't even fall unless that guy is, or that chiropractor is clairvoyant or can be, I mean, he can't be in 5 practices. It doesn't divide up. You can't be
or
in
I mean
5 places 50% of the time.
if you have clinics that are, open 2 days a week and you spend, you know, 5 days at, 4 different clinics or something. I mean, I think you could somehow, chop suey the math, I mean, I don't know. I'm not presenting it as like,
Yeah,
something we want people to do. I'm just saying, I
yeah,
think like public protection wise, I'm just not sure. I'm just having a hard time with that. Um,
yeah. That's got to be a rare beast in the first place. I don't know that that's, but I guess we have to consider all contingencies. Um, you know,
I think maybe if we
I,
can
yeah.
maybe look at some,
I think the periodic reevaluation thing and saying, maybe that those periodic reevaluations have to be in person. I mean, it just seems, I don't know. I thought there were merit in the comments that were made that if we have a direct order, but I hear what you're saying, Dr. Pears, that we have to think about our jobs that protect the public, and if there's even one of these types of things out there, we've got to think about it and be mindful of it. And short of telling somebody they can't have 5 satellite offices with only unlicensed people in, I mean, that just doesn't seem like the spirit of what chiropractic is about anyway. So, I have a hard time with that, but that's a whole nother discussion.
well, I mean, and we do have to consider too that, while the patients are, a major stakeholder, they're not the only one here. And so, we're talking about potential, I could envision, fraud and other schemes that
Yeah.
kind of might find a
Yeah.
loophole in this type of language that, you know, where we're not defining that there actually be a licensee, at some point, um, on site.
Well,
Yeah,
I have to
I
say,
don't know. I'm a
I have
little
to say,
stuck.
I have to say, I'm kind of at an impasse. I mean, none of this applies to me because I'm in my practice enough. So it's not a worry for me. I'm here. So I get where we're coming from. We're thinking about others. I was thinking along the lines of a guy that's a sole practitioner that wants to be able to have, a vacation. And during the week that he's gone, uh, short of, hiring somebody to cover his practice, if he doesn't have the means to do that, but wants to have people be able to come in and get ultrasound or e-stim or rehab or whatever while they're gone, this prohibits that from technically being done. this language prohibits that from being done. So the person essentially is shuts down their office and the staff that they have there that is qualified and perhaps has been doing that kind of physiotherapy on behalf of their patients for many years. And perhaps that goes on a lot. I mean, I have the benefit, I have other chiropractors that are in the office while I'm gone. So there's somebody here for them to access if they need to under an emergency situation if I'm unavailable. But I'm pretty available even when I'm not here.
Yeah, I mean, when I think about it, I think, definitely important to allow for some continuity of care, as you mentioned. Um, but I think too that that's really like, and I appreciate the consideration, but that's really a business decision, for them to say, okay, looking at how whatever their practice, however it runs, is this a wise business decision for me to hire somebody to come in and, be present, let's just say under what's currently there, 50% of this work week, and keep my business open for the full week while I'm gone? Or, should I make other arrangements, or, something else with the patients for that week?
Yeah.
Can they miss the care? Can I refer them to a colleague temporarily, or, I mean, give them home care for that week if it's appropriate, et cetera. I think there's other options, but I think that's really just kind of like a business decision for them. And I think the continuity of care is important in some way. You wouldn't want this, like, just you're abandoned for 2 weeks while I'm gone. I think that's maybe a separate issue. Maybe we need to talk about, I don't know, but that they would address that somehow. But it really becomes a business decision as far as coverage goes.
Okay.
So where are we?
Well, I mean, I think, we're, I honestly, I'm not really sure where we go from here, because I think you make great points, and I don't know really how to, I mean, I guess I feel like if people are going to commit fraud, they're going to commit fraud, and they're always going to find a way to commit fraud. Seems like that's just the nature of the beast. I think we need to make sure that we have the public protected and their ability to have continuity of care, as well as put in there, and hope that people are going to make good choices. I felt like a good compromise was, to reinstate that there's periodic reevaluations, and perhaps we drop the time to 25%. So at least you got to be there some of the time.
I think that's reasonable. I think
And
my
maybe that's a
concern
better
was
way to
none.
go. Maybe that's a better way to go. Yeah.
Yeah, I mean, my concern was really having none. It was completely abandoning the obligation to, have them present. And I think if we strengthen the language regarding, readily available, what that means, we strengthen the language about maybe, changing condition. And then I think assuming number 3 in some way, shape, or form makes its way back, then and also that language in there about in the first sentence on 3 that's struck out, but the individual's performance in relation to the patient. I think we really need something more along the lines of progress towards treatment goals, et cetera. That just is kind of unusual language for, um, you know, a
Yeah.
treatment plan and patient. Yeah. So I think it's so, but I think if we kind of update some of this language, I think 25%, and we define work week, what that means, maybe define that as actual patient care hours, not just like a 40-hour work week, but they're only open, 9 to noon and, 3 days a week or something. I'd be happy to move that forward, something like that.
So Kristen, where do we go from here? I mean, I know we've kind of gone back and forth, but I think we kind of settled on some things. And how do we? And Mr. Sweet or Raphael, do you have Any other input there before?
No, I
Okay.
think I appreciate Dr. Paris's point, even though I was comfortable with the language without having the percentage of time in the work week there. I think Dr. Paris makes a good point. So, yeah, I was going to ask Ms. Walker if she had recommendations on how we should proceed given our discussion.
I concur.
Thank you. I would say on that point, I think we've heard both sides. I think and even the compromises that have been addressed as well, I think staff needs to take that back. We could do a little bit more research on, Dr. Paris had brought up that, physical therapy board outlines some of the requirements, and then we can also look at other states. Some of them are actually licensing chiropractic assistants, but they might have some language there that's really outlining that role so that we can kind of bridge the gap on ensuring, if there doesn't need to be a time-based requirement, how do we make sure and have assurances in the language that there's an adequate control in place for the doctor's supervision? So I think we can certainly bring that back with some recommendations at a future discussion. This one isn't as close as the prior agenda item to being, I would say, ready for a full board motion. And then as far as a few other items that were brought up during the discussion, one of the concerns from staff was about the use of the term physiotherapy and if that language itself was in some way limiting. It's not defined anywhere in that regulation what physiotherapy is, so whether or not that includes rehabilitation or other types of modalities that an unlicensed individual might be performing. So we wanted to confirm that that term was appropriate, and then we would likely suggest that we define it and bring it back. And then the other point that was also discussed is the use of the actual term unlicensed individual to talk about what's essentially support staff and whether it may make more sense to give them some other type of definition, such as this just throwing off the top of my head, but chiropractic support staff, and then define that as an unlicensed individual and include the definition, and then carve out that support staff exclude someone that's otherwise licensed under, and insert the healing arts provisions within there. So those are some other two items that I think could be discussed. Another issue that I failed to mention during the background on this item is the language itself also carves out an exemption for preceptorship programs, which likely we're going to need to bring back for a future discussion by the committee, but there's no actual regulation about the preceptorship program within our current regulations, and it's not really defined here. It just is a reference to this regulation doesn't apply to that program. So that's another area where we see that additional work, I think, needs to be done in this area.
Ms. Walker, would that language relative to the preceptorship, or actually, I think it's more of a postceptor, right? You're talking about, or no, preceptor is the doctors that are, like I did a preceptorship where I worked in this office here before I graduated, and then I did a postceptor. So when you say preceptor, you're talking about the people that are, quote, still in school but have achieved their requirements and are allowed to practice under another doctor?
Correct. So there's both. So there's the portion while you're still in the degree program and you're actually in the formal preceptorship program and you're paired with a preceptor. And then there are instances where within the chiropractic colleges, there's individuals that they earn their degree, but they've not yet pursued licensure and they're kind of under a postceptorship, which isn't addressed anywhere in regulation. I think that needs to be addressed as well. But with this is very broad language where it's calling everyone collectively an unlicensed individual. And I would just suggest that maybe we try to give them some sort of title other than unlicensed individual. I would just say from the enforcement perspective, when we think of an unlicensed individual, kind of the presumption is that we're talking about someone that's out there practicing without a license, because typically when you see our enforcement statistics, we'll say we issued a citation to an unlicensed individual for unlicensed activity. So we might want to tighten that language up a bit to really reflect that we're talking about the doctor's support staff within the office and the permitted activities that they can perform there.
Would that fall under a different regulatory section then, or would it have to fall under this? Like, do we have to include that language within this framework, or is it be something that we would just create another bullet point?
We would propose in a future discussion at the committee, which we would bring language to, but we would propose a separate regulation section relating to the preceptor, postceptor
I
program.
agree.
Just
I agree, because
make
I
sure
wouldn't,
that's part of
want to hold this up. I wouldn't want to hold this up because we got it. That thing seems like that's going to require a lot more working out than I think we're close to getting stuff done with this. So. So I think the language in there that says that excludes the preceptor and postceptor areas, I think is good. So this keeps it just to quote the unlicensed individuals, the chiropractic support. I'm comfortable with that being chiropractic support staff, because then it kind of defines that they are there supporting the chiropractor. And then I love the language you put, I can't remember how you said it, that this does not include support staff that has their own licensing regulatory boards. I think that clarifies that.
Yeah. I think that's
so we can bring back and some updated text with some of those changes that we've discussed here today. And then the other question would be about physiotherapy treatment. Is that term itself broad enough to really include the different activities performed by support staff? Do we need to look at adding additional activities or describing them here in the regulation? Or is it just a matter of when we define physiotherapy, having a broad enough definition? Because we wouldn't want to put forward a definition that would exclude some sort of future device or treatment that's going to happen, but we want to make sure that it's not limiting with just physiotherapy.
My 2 cents is that I've always considered the physiotherapy to be inclusive of any adjunctive activity supportive of the adjustment, if you will. So that would include, but not limited to, type language that would be like, modalities such as, ultrasound or e-stim or microcurrent or laser or so on and so forth. And that would include, in my opinion, rehab recommendations for spinal exercises, brain-based exercises, those things that include the physiology and the improvement of the physiology of the body, whether it's through exercise or through modalities. That's how I've always interpreted physiotherapy.
Yeah, I think the definition, as you stated, Dr. Adams, has to include modalities is a very common language to identify some of that, and then probably exercise or rehabilitation exercises maybe as a broader, that way you're including orthopedic type exercises, neurologic type exercises. I like some language around that would be, the example you gave was I think was really good.
Can we use language that says including but not limited to, that kind of gives that, kind of like is the and such like verbiage, Give a few examples, but, without saying that we're trying to say this is the prescribed areas, because, some people get real literal. We don't want them to think this is all we're saying, but things like this, if you will.
I believe so. We can work with regulatory counsel to come up with something to that effect. I think a broad definition that would be all encompassing is something that we can develop, and then we can certainly also include examples but are not limited to, and that way we can provide a little specificity and guidance as well.
I like that.
And then and this may, and let me know if we can move this to another day or time, but I think one thing when I think about postceptorship, and I'm happy that we're addressing that, I think it's important, but do we need to maybe have a discussion around defining a time frame? In other words, how long can you be a postceptor and be, unlicensed but working under another provider's license.
I would agree. That has to be part of the discussion because there's a difference between the preceptorship program within the unit and then you get your degree and you're doing a postceptorship for a quarter or a term versus, occasionally we'll see the enforcement case where someone's been a postceptor for, years, and that's not necessarily appropriate.
My recollection when I did my postceptor, I did a preceptor for 6 months, and I think I did a postceptor for 6 months. Then I got my license in the fall. But I think I could have done. I think through Life West, you were allowed to do up to 3 6-month stints, and then after that you were done, because that gave you. They were doing the board back then every 6 months, so you had basically 3 shots to get your license. To get to pass the board.
What would that equate to now?
That was my recollection back then. So part 4s, I think, is the same, right? Isn't part 4s every 6 months roughly?
Yeah, I'm not sure.
I think it's May and November, correct?
Yeah, I'm not clear. I'd have to look it up.
I'm pretty sure
so maybe we need some information to come back to kind of define that. I mean, I would think it's easier. I know I had the same situation where when I was graduated, I was getting ready to take the state test and I couldn't get my high school to send my diploma. And so I missed the first, and then you got to wait 3 more months or however long it was. And, yeah. So maybe we could gather some timeframes on the frequency of MBCE and make a better, but I think 12-ish months, something like that, is, like you mentioned, is probably in the ballpark.
Perhaps, Ms. Walker, we might contact some of the chiropractic schools and see what could. I don't even know if are they still, to your knowledge, are they still doing postceptors out of chiropractic schools?
They do still have them. I would say for purposes of today's discussion, we will certainly bring that back as a future agenda item with background information. And part of that background information would be reaching out to the colleges to see who they're approving under a postceptorship type program, and then kind of reporting back the results. I mean, there's only 19 colleges, and we can get data from all of them and report back to the committee when we discuss that topic.
So circling back then to, this section that we're dealing here, do you feel like with our discussion and our compromises and our thoughts that we've given you enough that you can rework some of the language, kind of bringing number 3 back in, maybe defining the readily available a little bit further so that we might define that? Because I think that is a little bit vague. Not a little bit, it's a lot vague. And then the 25% option as opposed to 50. Do you feel like you have enough?
We certainly have enough to bring it back and to take all of the committee's discussion here today and update it. The only remaining item there, and it's really a policy decision, is around the public comment that we received at the board meeting about the potential need to exclude individuals whose licenses have been revoked from being able to serve as support staff, and whether or not we want to try to attempt that through regulation, or one issue with that, with basically the circumstances of that issue, is that that our extent of regulations can really only reach to a chiropractic office and staff that's working for a chiropractor. The problem itself is much bigger than just this board, and it does really affect all the healing arts boards. So it may be something that's more appropriate to try to pursue first legislatively, or we could try to incorporate it here into our regulation, at least to exclude within the chiropractic office.
Yeah, I remember you bringing that up when we spoke, and I agree. I think we probably should look at having something in our language that gives us some teeth. If we learn that a chiropractor knowingly, I guess, or unknowingly, I would assume they would know the background and that person would disclose it. But I guess if they don't have a license, perhaps they don't have to disclose it. But if a chiropractor is employing somebody that has lost their license for sexual misconduct, that they could be disciplined.
Okay, so we'll bring something to that effect back as well with the future language. Kind of the intent there would be we do lose any jurisdiction over the former licensee after the license is revoked. But just like you said there, we could draft something to the effect of it would be grounds for discipline against a licensee for knowingly employing such individual as a chiropractic staff involved in, direct
Patient care.
patient. Would it be acceptable or not to the committee to have that individual be able to serve as in an administrative role? Or would you like to see language that excludes them entirely from the practice?
Well, I think we've had enough, but my feeling just real quick is, we've had petitioners that have come forward that have had sexual misconduct, that have worked in chiropractic offices in the billing and helping out, and they haven't had direct patient care. And we kind of, want to know what they're doing to keep themselves in the profession and that kind of stuff. So I think in light of some of the stuff we've had with previous petitioners, my feeling would be that they should not have direct patient care. Certainly, unsupervised direct patient care. I don't know, maybe we could have a caveat for direct supervised, stuff, but certainly no unsupervised direct patient care if they've lost their license for sexual misconduct. Any
Yeah,
thoughts from the committee?
yeah, you bring up a good point actually that our expectation would be to see them as petitioners making an effort to integrate themselves back into the profession. And I think what we heard previously was a complaint about having an unlicensed practitioner who committed a violation in the office with the patient, that the violation was against, I believe, right? If I recall that correctly. So I think that I think our language has to specify, as you mentioned, kind of the guardrails around not just their participation, because if I recall, and I may not recall this completely correctly, but the complaint was not necessarily that that unlicensed individual was participating in the care plan, but that they were participating in the kind of administration and management of the office and were like present in the area. Was that, and it was an uncomfortable situation, was that correct?
For the complaint that was brought forward as a public comment, there was an individual that was a licensee that was working in a chiropractic practice. Their license was revoked by the board for sexual misconduct, and they're still employed by the same office. It's actually a medical corporation, so we wouldn't be able to solve it through these regulations, but they're still employed in the same office doing administrative front office tasks as well as chiropractic support roles, because there's nothing that currently prohibits it.
Did you have a comment, Dr. Paris?
I'm not sure. Go ahead. I'm thinking because it gets really difficult to balance the ability for a petitioner to integrate back into a chiropractic office and at the same time address the complaint, which I think is a valid complaint about having to face that in the office or in a office.
My answer to that is I sympathize with the victim, and I think that where we get into this is that our job as a board is that, we want to see the rehabilitation. When they come before us as a petitioner, what have they done to rehabilitate themselves? And to not, and to also not be punitive when they're paying their price, in a sense. So they've lost their license, they're trying to be employed, gainfully employed. I think we need to have parameters around that for a doctor. If they do participate in a practice, that they cannot be with direct patient care. And as I sympathize with the victim, I don't know that we can preclude somebody from, that we're trying, if somebody's wanting to eventually come back to the profession after they've lost their license for making that mistake, as long as they are abiding by those, because as Kristen points out, we don't have any jurisdictions once they've lost their license. So where we do have jurisdictions over the licensed chiropractor that may want to hire them and put them in a position where they could offend again. And I think that's where our protection of the public has to be. And that is to make sure that if a doctor does hire an unlicensed person that has had their license revoked, they cannot be in direct patient care or unsupervised patient care. And maybe we just say, no patient care whatsoever, only an administrative section. Or we say for a time, maybe for a few years, and then after they've, mind their P's and Q's and haven't had any additional issues, that maybe after a certain amount of time. So I certainly think we should consider lots of options in that, to be sensitive to, but we also want them to be, keeping their skills sharp if their intent is to, rehabilitate themselves and come back. So maybe strike a balance somewhere in there.
I mean, we could consider, is there the potential to limit the exposure by limiting their ability to practice in the same office, or I don't know, I may be getting off the rails here, but in the same office or at the same address at where the violation was committed. Like, can we limit them based on in the same practice, coming back to the same practice or the same office?
Well, but sometimes those offenses aren't. We had a petitioner before us, a very prominent chiropractor that came before us, and his offense was off-site.
Right.
But he's on probation for that. So
yeah, it's true. Yeah, I think we'll have to look at some like further language maybe, and then kind of develop it. The other thing is too, I think if we flip the stakeholder here again and we make it a just as a consideration, not to clog this discussion, but if we make the stakeholder like an insurer, say it's a fraud case, I think we have to define sometimes like the area that they're working in the practice, because we wouldn't want them to say, well, you can be our biller and our coder, and then this was like a massive fraud case, had nothing to do with, any sexual contact or anything like that. So,
good point.
yeah, so I think we need to just kind of broaden the stakeholder consideration when we're developing that language. And if we can limit them to certain areas of practice and maybe not allowing them to practice in the area where they've committed a violation. So if it's patient care, they're excluded from patient care. If it's
That's a good point. That's a
if
good.
it's insurance fraud.
How would that language work, Ms. Walker? Could we say that an unlicensed individual cannot work within a chiropractic office as an unlicensed individual in an area where they had had violations?
I'm confident we can develop some language that's going to reflect that intention. And then like we've discussed, the enforcement mechanism is going to be against the employer or the licensee that's providing the supervision, because we don't have the the jurisdiction there, but we are outlining kind of the acceptable structure there for the chiropractic office and their support staff and the roles of support staff. So I believe we can carve out some exceptions or restrictions on people that previously held a license. So we'll work on that language. And then, yeah, it's all going to come back to the enforcement mechanism is going to be related to the doctor of chiropractic and it'd be unprofessional conduct for them.
Yeah. Okay. I mean,
Yeah.
I think there's a lot there. So
Yeah. Yeah, there is.
yeah.
Mr. Sweet, any comment or?
I think we've had a very thorough discussion on this matter now, so I think we have our next steps set forth.
Okay. So Ms. Walker, do you feel you have enough to bring us, get us back to the next committee where we can do a little more diving into this, perhaps?
Yes, definitely. We have the notes on all of the committee's discussion today, and we have plenty to work on, and we'll bring it back at the next committee meeting.
And we don't need a motion to bring it back to committee, only to move it to the board.
Correct. No motions needed. We would just need a call for public comment on the agenda item.
Yeah. Okay.
Great.
Sabina, do you have anything to add on that? Are we okay just going to public comment?
I think that's a wonderful idea. As Ms. Walker already indicated, we have lots of notes. We're ready to rework the language and bring it back to you for review yet again. And trust me, this is not the last time you all will be seeing this. So you might be sick of it after a while, but
I think it's important. I know it sometimes, gets a little bit, but I think we're thinking about all the potential things here, and that's our job, is to try to do the best we can.
Absolutely. That's how it gets fine-tuned. So this is why committees are so great. You do the heavy lifting.
Thank you. So let's open it up for public comment, please. Thank you.
And we've opened up the WebEx Q&A feature to facilitate public comment. If you have a comment on this issue, you can either look for the question mark icon in the lower right corner of your computer screen, put the word comment into the text box and click send, or you can raise your hand by clicking on the hand icon, and call-in users can raise their hand by pressing *3. And we have no public comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Okay, let's move to agenda item 6. This is review, discussion, and possible recommendations regarding proposal to amend or repeal CCR Title 16, Section 354, successful examination. Turn the time to Ms. Walker to take the lead.
Sure, thank you. So as outlined in the meeting materials, there's one of the board's regulations, Title 16, Section 354, successful examination, became effective in 1979, and it currently hasn't been amended since that time. It still states that applicants who are notified in writing by the board of successful completion of the board examination may immediately commence the practice of chiropractic in California pending the receipt of their certificate. Staff has significant concerns with this regulation as it conflicts with Section 310.2, as well as Sections 5 and 15 of the Act, all of which prohibit an unlicensed person from practicing chiropractic. In addition, this regulation causes confusion for those in the licensure process. Currently, our vendor administers the California Chiropractic Law Examination. Applicants go and they complete the state exam, and they're immediately notified in writing that whether they've passed or failed that examination. But the licensure process doesn't stop there. As the final step for licensure, they need to take that pass letter and submit it to the board along with their initial license fee. And then after we receive that information, staff performs a final review of their entire application package, confirms that all requirements have been met, and then issues them a Doctor of Chiropractic license. Or in rare circumstances, we could find that there's grounds for denial of a license, and instead that applicant would be notified that their application has been denied and provided with the appeal procedures for them to appeal that determination by the board staff to the full board. So the reason we bring that forward is the staff recommendation on the item is rather simple. We recommend that the committee and eventually the board consider simply repealing that regulation due to the inconsistencies with Section 310.2 and Sections 5 and 15 of the Chiropractic Act, and just general understanding not only within chiropractic, but the public that licenses are required in order to practice chiropractic. Alternatively, the committee could also consider instead amending the regulation to clarify when the point that practice would be permitted after successful completion of the law exam. And the other major concern there too is, a lot of this assumes that the person, after they've passed the exam, will follow through and obtain the license, but the wording of the regulation itself would allow them to practice for some indefinite amount of time. And there's not even a time frame involved that they're going to immediately file their application. And like I said, there's also the concern that there may be grounds for denial of a license. So that's the staff request for the committee today, is to either consider repealing this section entirely, or alternatively, we could work on amendments. And if the committee concurred with repealing it, then staff would request that they make that recommendation to the full board and we could bring it there for discussion. If we need to make amendments to the regulation, we would bring that back at a future meeting just to reflect this discussion today.
My question would be, that all sounds very reasonable to me. What is the most efficient from staff recommendation? Would amendment or repeal be the most efficient and the best objective?
The staff recommendation is to repeal. The license process itself is in regulations, and that's something that the licensing committee can work on clarifications to the entire process, and as part of our broader strategic plan objective to clean up the regulations. It would have a much more immediate effect if we were to just repeal this loophole, if you will, in our current regulations that'll basically allow for unlicensed practice after passing the exam, but before formally receiving a license.
So is this under our jurisdiction as the enforcement committee, or should we kick this over to the licensing committee and let them make the decision? Can we make the decision today here?
I would say it's under the enforcement committee's jurisdiction, if you will, today, because it's an issue of unlicensed practice. If following the committee's discussion, the committee, rather than repealing, if there's discussion around simply amending regulations to reflect the current process within 354, then that could be referred over to the licensing committee instead.
I would make a motion to move to the full board with a recommendation to repeal CCR Title 16, Section 354.
I'll second that. Any other discussion?
That's the most efficient way to get this done. I think that's good with me.
I agree. Any other discussion, Dr. Paris?
None from me. Thank you.
Moderator, can you open up for public comment, please?
Certainly. We are opening up the WebEx Q&A feature to facilitate public comment. If you'd like to comment on this discussion, you can look for the question mark icon in the lower right corner of your computer screen, type the word comment and click send, or you can raise your hand by clicking on the hand icon, and call-in users can raise their hand by pressing *3. Each person will be given 3 minutes to speak with a 30-second warning. And I see no requests for comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Dr. Paris, will you call the vote, please?
Yes, Dr. Adams.
Yes.
Mr. Sweet, and Dr. Paris is a yes. Motion passes.
Thank you. Okay, public comment for items not on the agenda. Ms. Walker, have you received any public comments? Since the agenda has been set?
No, we haven't received any written comments for today's meeting.
Thank you. Members of the public, you may address the committee at this time. Advise the please identify yourselves and your name will be recorded in the official minutes of the meeting if it is provided at that time, at the time of your comment. Moderator, will you please open for public comment?
Of course, we've opened up the Q&A feature of WebEx for public comment. If you would like to suggest an item for a future agenda, you may, or a item that was not on this agenda, you may look for the question mark icon, type the word comment and click send, or raise your hand by clicking on the hand icon. Call-in users can raise their hand by pressing *3. And I see no request for public comment. Shall I close that, or we're going to open it right back up for the next item? Is that correct?
Yes, thank you.
You're welcome.
So agenda item 8, future agenda, open this. Is there any items from the committee that future agenda items?
And for me,
None for me.
Okay, we'll open it for public comment.
Thank you. And if you have a suggestion for a future agenda item, you can look for the question mark icon, type the word comment and click send, or raise your hand by clicking on the hand icon. And call-in users can press *3 to raise their hand. And I see no requests for comment. Shall I close that public comment feature?
Yes, thank you.
You're welcome.
Okay, next agenda item is future meetings. So scheduling of 2023 committee meetings. So we'll open this discussion for setting our committee meetings for the future. I want my 2 cents. I really like these shorter meetings like this where we hit stuff hard and I think this is a good system. It works well with my schedule too. I hope it works well with your all schedules. So I'd like to continue this type of aspect if we can. Having said that, any other comments or suggestions?
I agree. I would also suggest if maybe I appreciate doing it here on the call, but it seems like the doodle poll sometimes, and with an acknowledgement that we want to have the committee meeting before, and the dates of the full board meetings. Sometimes that's a little bit easier because I think I have a little more time to go through some calendars and check in on things and really confirm these dates. Versus trying to kind of, doing them here on the call is nice to get them done, but I think they're kind of tentative when I do them this way.
Yeah, I concur. So, Mr. Sweet?
yeah, I think that's a good idea. I mean, I know we banged quite a few out at the last board meeting, but I'm fine with doing a doodle poll as well.
Okay. I'm good with that unless you feel like we can at least set one and then doodle pool for the remainder. Is that
Sure.
is that agreeable that we can you said we want to try to do one in the spring, Ms. Walker, is that correct?
Yeah, the idea here, so we have 2 motions from the committee going forward to the January board meeting. So we would just want to set the next committee meeting ahead of the April board meeting so we can have more agenda items that are ready for the committee's discussion and then potentially moving forward in April. We would recommend looking at late February, mid-March, no later than late March so that we have adequate time to prepare any final items before the board. And then in addition to scheduling if you schedule the very next one on this call, if there's any particular preferences on dates for the poll that's going to go out for the more future days, if you could state those just so that we don't poll for days that already don't work on someone's schedule. Not
Excellent. So,
but days of the week.
yeah. So what are, I'm okay with Fridays. I would prefer like a Tuesday, Wednesday, or Thursdays. Is that better for staff, or is that okay for staff, or for you guys, for all those on the committee?
With the notice and these shorter meetings like this, I can carve it out with this much advance notice, a couple of hours at a time.
Now your schedule has changed, I recall, on Fridays. So your Fridays used to be better. Now they're not as good.
Yeah, they're a little more difficult, but we did the CE meeting, and so I'm open to other days if
Should we look for a Wednesday or a Thursday? Tuesday, Wednesday, or Thursday?
Mr. Sweet, what about you?
I don't have too much preference, probably maybe a slight preference for a Thursday versus a Friday, but I can make either one work.
Thursday's good for me too.
Okay, those are always really good for me. I mean,
Let's do it. Let's find a Thursday.
so I was just looking at it. What does Thursday, March 9th look like for you guys? I think that gives us enough time. It's early enough in March that it's before the April meeting.
Do you have something on the 9th which might change, but which will probably change, but I'm open the 2nd or the 16th as well, so I could probably make it work on the 9th if it needed.
I'm okay with March 2nd. Is that okay with you, Miss Walker?
Yeah, that would be fine.
How about you, Dr. Paris?
Just give me 1 second. I'm checking a few dates right now. Did you say March 2nd?
Yeah, March 2nd. Mr. Sweet Raphael can't do the 9th. I can't do the 16th.
Okay, let me just check. Let me check 2 dates here.
And I think the 23rd would probably be too late.
Yeah, the 23rd I cannot.
Well, I think it'd be too late for what Miss Walker had pointed out for the board. We would probably want to be sooner than that.
Yeah,
I
I
have
can't.
March 2nd open.
Let's do the 2nd if that works for everybody. I can't do the 23rd anyway, so
Right.
yeah.
So March 2nd for you, Mr. Sweet?
Yes, sir.
Okay, so Miss Walker, can we just pencil at least the first committee meeting, and then we can do a doodle pool for subsequent meetings?
Sure, and it sounds like Thursdays work well for the committee members, so we'll pull some Thursdays together later in the year and send out a poll. For that March 2nd date, do you have a preferred time that we hold the meeting? Do you like the 12:30?
I like this time because I think it works well for people's lunches, and what's the committee think? Because Thursdays typically are open for me, so I can do different times. You know, I prefer the earlier the better, but the lunchtime is fine.
I could start at noon. That would help me just a little bit. But
Mr. Sweet, what about you?
Yeah, noon would.
Noon's fine. Noon's fine. Noon's fine for me. Whatever's going to help you, because Thursdays are days I'm not working. I mean, I do paperwork, so I can step out. Yeah.
Okay, so 12 to 2.
12 to 2 sounds good. Does that sound good for you, Miss Walker?
Yeah, that's perfect. Thank you.
Okay, great.
I like it.
We got the first one
Check
done,
that
so
off.
we'll doodle pool the rest, and we got a date for March 2nd. Perfect.
Awesome.
Okay. Do we have to have public comment on that? I guess we do. So can we do we have to make a motion on that, or is that no? Okay. So let's open that for public comment.
And this is the moderator. We're opening up the public comment for input on the future meeting date. If you have any comment, you can look for the question mark icon, type the word comment in the text box and click send, or raise your hand by clicking on the hand icon. And we have no requests for comment. Shall I close that feature?
Yes, thank you.
Thank you.
All right, we did it. 2:30 on the dot. We're getting
Well
better
done.
at this. We're getting better at this.
Well done.
All right, you all have a fantastic and wonderful holiday season. Thank you so much. Thank you, staff. Thank you, Miss Knight, and everybody else. We appreciate it. And be safe.
Same to you.
Thank you.
Thank you.
Happy holidays.
Thank you.
All right.
Here,
Take care.
everybody.